Hi folks, so this is the continuation of chapter 13 on intellectual property, and I'm recording this so that we can start next lecture on chapter 14. So we now look at confidential information and what confidential information is. Some examples are customers list, employees information, personal information, suppliers list, marketing strategies, marketing processes, everything that is or was developed by the employer. So with confidential information, the duty is actually not to disclose the confidential information, because by disclosing it, you would certainly cause harm to the business, or you could even have some personal benefit, like offering to a potential new employer or a competitor. So the duty is actually not to disclose it. And how is this duty created? Usually employment agreements will have a non-disclosure prescription or clause or section in which you, the employee, would be bound by this obligation or duty not to disclose any confidential information that you had access. But it could be also just a non-disclosure agreement you have with your friend because you want to share some confidential information with them to get their opinion, their ideas, but you don't want them to disclose it to anyone else. So you could just sign a non-disclosure agreement with them. And once this agreement is signed, so what you need to do is you need to mark all information that you are sharing, which is confidential. You have to mark it as confidential. You have to identify it as confidential. So this information cannot be disclosed. And if it is and brings the other party personal benefit or yourself, your company, a harm, then you can sue for damages. We also have trade secrets. Trade secrets is a subset, is a type of confidential information. And the trade secret is confidential information that creates a competitive edge to the business or to the person. And the information that is regarded as trade secret has to be valuable to the business and cannot be commonly known or readily available. So my question is, what is the most famous trade secret we have so far? At least in my opinion. I'll give you 10 seconds to think about it. Okay, almost 10 seconds. So you may have probably thought about KFC sauce recipe. Yes, that's a good example. But for me, the most famous one is Coca-Cola syrup. So the syrup is kept under as a trade secret since it was created back in the 90s, early 90s. And it is valuable because it is a secret. So other companies have tried to copy Pepsi, all other cola companies, but what they could manage was to get close to Coca-Cola. But for me, I'm a Coca-Cola addict drinker, so they are not the same. Coca-Cola is Coca-Cola. So the syrup, the formulation is not. It is considered a trade secret, but the value or the proprietary right is not on the formulation itself. What we deal with, legally speaking, in trade secrets is with the wrongful act of people that had contact with those trade secrets to share that private information. So the wrongful act is there, the misconduct is there. What if Coca-Cola had patented this syrup formulation? It would be in public domain since the 1920s or so, and everyone could use the Coca-Cola formula. So because they kept it in secret and they were successful in keeping it a secret, then we can call it a trade secret. If you decide to keep it a trade secret, you have to make sure you can keep it a secret. So as a business person or a potential business owner with a trade secret, you would need to consider, should I keep it trade secret or should I patent this? Well, first of all, you need to know if your creation or invention is patentable. If it is, then this question is applicable and is relevant. With trade secret, you don't need to register, you don't need to apply, you don't need to spend money with patent agents everywhere in the world, etc. However, if you cannot keep it as a trade secret, or if the current technology or future technology allows people to, for example, reverse engineer and find out what your trade secret is, then you have lost it and they are not violating any rights. That's actually what Pepsi probably have done, and other Coca-Cola companies did as well. For a patent, yes, this would be protected for 20 years. You have the monopoly. However, you have to apply nationally, and then you have to apply to any other countries you want this patent protected. You have a lot of money to spend in this application. And after 20 years, it is in public domain. But if, for example, the technology available nowadays allow people to find out what your product is, if you have a patent, you are still protected, because if they can use it, if they want to use it, they have to get your consent and eventually pay you royalties or fees. So that's those are some of the questions you would inquire yourself with regards to, should I keep it trade secret or should I patent my invention, my creation? Moving forward, what are some remedies available for the violation of rights with regards to trade secrets or confidential information? So you suing the plaintiff, you would have to establish in court that the disclosure of information caused you harm. And then if you establish that, you can get an injunction. So in order to stop, the person should stop disclosing to others. Let's say they have published online, they have to take it out, or they are sending emails, they are sending written forms of your trade secret or confidential information, so they have to stop it. You can also get damages, and if there was bad faith or malice, you could get punitive damages. And accounting, you could also get if they have benefited or profited out of your confidential information or trade secret. So accounting is turning over the profits they made to you. You could also have some tort claims, such as inducing breach of contract. The example is you as an employee were in a confidentiality agreement duty, and then after you left the job, you went to another job, and your new employer has induced you to breach that contract, has eventually or potentially offered you some money or some promotions if you disclosed the confidential information you kept with you. So in case you were induced to breach your contract, your former employer could sue your new employer for having you induced to breach the contract. And then in terms of private information, so what private information is? Private information is any information that is capable of identifying a person, an individual. So if you have my name, yes, this is private information. But if you have my address, if you have my ID numbers, SIN numbers, etc. So for private information legislation, we have in Canada legislation on federal legislation and also provincial legislation. The federal legislation is mostly related to companies that are of federal interest, so they apply for the government. Yes, I was forgetting that, but they also apply for companies that do business interprovincially, or banking, or airlines, transportation companies. So all companies that have interest to the federal government. And we also have provincial privacy acts. So they apply to all other companies, institutions, and organizations. What is the key point for any private legislation is that there's a high burden on the company or organization or institution collecting this information. So, for example, when we call the MSP, there's a message while we are waiting to speak to someone, which says that by keeping on the line, we consent to personal information to be collected for identity purposes. So MSP is first getting our consent, and second, disclosing what the purpose of collecting that information will be. So those are key aspects of any privacy legislation, not only in Canada, but worldwide. Companies, they have to get, companies, institutions, or organizations, they need to get our consent first. They need to disclose what the purpose is. And if they change the purpose, so let's say MSP wants to use our the personal information collected now for marketing purposes or for survey purposes, not for identity as they said, they would need to get another consent. So whenever we disclose a purpose and we get a consent, but decide to use the same information for other purposes, we need new consent. And companies also have a duty, companies, institutions, they also have a duty to keep our personal information safe. They have to inform the authorities, government authorities, if there was a breach, hacking of our information, so information was stolen. And if they don't do this, they may be highly fined. So there's a lot of fine. And this is a very hot topic. Last May, there was this general data protection regulation coming in force in Europe. And you may have received some emails to confirm or update the terms and conditions of some companies. And you may ask, but why am I giving another consent if this is only applicable in Europe? Yes, that's only applicable in Europe. But this regulation also says that if foreign companies collect information of European citizens, they are bound by this new regulation. So Canadian companies, American companies, they collect information on citizens from all over the world, including European ones. So they have decided to update their terms and conditions. I believe last May or June, you may have received 2, 5, 10 emails to give your consent for the updated terms and conditions for some companies. And one other important aspect for protecting private information is that if we disclose our information on our own, for example, in social media, LinkedIn or Instagram, Facebook, if we disclose what our address is or any document numbers, I know it may sound awkward, but if we do it on our own, then we are waiving our privacy on the information disclosed. So that is also important. By the way, I have uploaded some information for you, some article, I believe one article, and some more information on protecting private information, if you want to go further into this. And just to finish, in Canada, we also have the Combating Counterfeit Products Act, because, as you know, violation of intellectual property rights online is very pertinent, and it happens a lot. So this act has expanded the definition of trademark, also created some other criminal offenses. The idea here is to avoid such violations to take place, and also expanded some powers of enforcement. So copyright boards, they have more powers to enforce, and etc. So it goes like this. Because before the 2012 amendment, there wasn't efficient enforcement powers for this huge online piracy, online violation of IP. But there's still a lot of challenges, as you may know, because technology is just evolving very fast. In terms of dispute resolution, the main thing here is that I told you for trademarks and domain names, a person who holds a trademark has the right to have a domain name on their own trademark. So in case someone else registers a domain name with someone else's trademark or a company's trademark, this company may start a arbitration process, mediation and arbitration process through CyberSettle or through the mediation and arbitration center at the World Intellectual Property Organization, WIPO, and those mechanisms, they are very, very effective, because if the person who registered domain just is silent, does not come to this process, believing that they will still keep the domain, those centers, for example, the World Intellectual Property Mediation and Arbitration Center, they have a lot of powers, and one of those is to enforce, to request, to actually demand domain names, registration companies to freeze that domain name in dispute, and also to transfer them to the rightful owner of the trademark. So they are very effective. 15, 20 years ago, companies would need to make a bid to buy that domain name. For example, let's say bmw.com.br. I had registered this in Brazil just because I was smart and it was available, and then I would offer for BMW to buy it. And a lot of companies bought domain names in the past. But nowadays, BMW could just start this mediation and arbitration process at WIPO, and even if I try to defend myself, but I'm not the owner of the BMW trademark, I would probably have to transfer it to them, or if I just didn't show up for this mediation process or arbitration process, WIPO would force the registration company in Brazil to transfer to BMW. So they are very effective. And by the way, there's nowadays we can find lawyers that are specialists in those domain name disputes. To finish, so last but not least important, the criminal code has some prescriptions for criminal offenses, such as unauthorized use of computers, so people that hack others' computers. Also, mischief regarding computer data, if you access, even legally, but you then use it in the wrong way, data from others, and if you intercept private messages. They are all criminal offenses, and besides the civil damages, the wrongdoer may have to pay. This person would also face criminal charges. There are criminal offenses in the Copyright Act as well, in the Trademarks Act as well. But the best defense for ourselves, our best way would be to try to use only encrypted data, encrypted tools to use or to transfer data, to send data, so that we are kind of protected. So I trust you have enjoyed this. Again, I speak too much, so I thought I was going to just spend 10 minutes with those slides, but I spent 20, and I hope this is clear to you, and I'll see you in class for chapter 14. Do not hesitate to reach me through my email if you have any doubts, issues, any comments. Thank you. See you next time. Bye-bye.